Warlock, storage facility, Fishama, international Fishama, then they call me Fishama, international Fishama.
Asaase Radio 99.5.
Yangwe, Mole, Yangwe, Gabuale, Crew Bravo, Book Back, yeah, Nakai, check it out. I'm going to come, I'm going to come, I'm going to City Remabula 4. I'm going to come, I'm going to come, I'm going to Tabi Remabula 4. I'm going to come, 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 I'm going to come. My power says.
I'll try my best.
Somebody from the Shona, somebody from Fratinga.
I'll try my best.
No mercy for the cripple, no mercy for the Atlanta. How much more the cripple? Before we J by force, it's simple. Be there, JQ, J sample. Before backsliding, in it for example. Once upon a time, you can't pay your machakuna. I told the man, is here close to Shona. If you're my plain, no corner. My name is Mana, my name is Sakakili, in Wenanglo, in Wena, Thomas Sickly. Talking to the girl in Mamiba, in Bafili, in Bula Blafos, me believe you, man, I be me schooling day, in Willa Easy, Abapana 1 elementary, for my Sato, a Chomini, 11 actual Lukoto, 1, 2, Bakri my shoe, none in legit small boy is canoe, Humpty Dumpty until I'm sat on the wall. I call bluff for where I saw the original play all. Amo, tomato, onion, sabolai, amalai, Davida, I can never lie. I swan, man at the University of Legon, and I can bluff for Tomo machine gun. Oyamla Matuyamia, listen to the song. Come back, in here I'm going to come.
Try my best. Fish farming is the process of rearing of fish in reservoirs.
Okay, well, we're going to try our best, whatever the circumstances are. And I think the arguments are clearly, on both sides, pretty solid. It's interesting that this has become the one that sort of sets has become the one. The others were like, they were news leaders in terms of statements made by the ministers that you might listen to this and say, oh, okay, we didn't know that, so it becomes a headline. And this has been more, not so much about the substance, but about the seeming lack of performance or the performance thereof and those things and the expectations of ministers in general, but not speaking to any of the substantive issues in aquaculture and fisheries. Did you notice that? Because that's what I got out of it, that people were more focused on, it's an opportunity to tease somebody.
Well, yes, I think, in the way it's sort of, in the way that the sort of round robin exercises are, it's sort of crystallized many issues for people. For some people, it's about language and lack of fluency or fluency. For some people, it's about the woman thing. I suspect it's not for you, Kujo. For some people, it's about representation. For some people, it's about mastery of the brief and if you understand the ideas behind what you're doing. And for some people, it's just, it's highly politicized and a sign of somebody's kind of sense of complacency in the position.
But the only thing we're going to make sure about, look, let's not, I think that at the end of the day, there is a right to have a differing opinion on these things and to say, oh no, I thought this. But what is the standard? And I think that's one of the challenges we have is there a standard? Is there an expectation? What, if anything, were we supposed to have been looking for in advance of? Because everybody has their opinion about what should have been the expectation. And in that, we then have the problem of what then the minister or the minister designate should be delivering at this particular type of event. But I also wanted to point out that it's not been fair Personally, I didn't think the vetting was fair all round. In terms of some people got pressure in a certain area, and others it seems to have been very much a case of, I'm going head to head with you on the intelligence point on this because I think you know all this, so I'm going to challenge you with this. But others, it's about, let me find your weak spot and just push that agenda without actually trying to extract anything. I would hope that if I went to a job interview, the purpose would not be to just simply try to,
harangue you into something.
Yeah, or to find ways to make me stumble. That can't be the purpose of a job interview.
You see, people will reason about this in all sorts of ways and say, but that is what it is like being a government minister, a cabinet minister in the public gaze, that you should expect to be in a position where people are trying to score political points off you and will subject you to those kinds of pressures. So if you can't withstand the pressure in a vetting committee, what are the chances you're going to be able to do it later on in your job, however artificial the vetting committee setting is?
You know why, for example, you'd go with your CV that speaks to some of your past experiences, and your past experiences may not necessarily have to be all geared towards what you're going to apply for, but speaking more to your overall general competence. Now, if you don't ask questions based on that CV, and you simply want to punch holes in what you think is my character and things like that, then you are missing the point.
But but the CV isn't everything, because
no, it's
after
not,
all, in a CV you can present a highly edited version of what you want the world to believe.
Yeah, but you can still ask me questions about it.
Yes, you could. Well, in a way, they that the people on the members of the appointments committee will argue that is what they were doing. They were asking questions, in the case of Honourable Harricomson, about her knowledge of the sector and the government department and its structures and the way it works, and what the general policy outlook specific to that department is. It's a very complicated area, and I'm not saying that kind of any one emphasis on one aspect is any better than the other. I just find it very interesting that it came to bear in this particular case.
Right.
This particular case being a woman who is a politician of a particular kind, who has a track record of a particular kind, and who is known not to be terribly articulate. And as you say, what is objectionable is when you get to a position where you're not going to get a satisfactory answer, you're not going to get the kind of answer that you want, and you keep on coming back and asking the same question over and over again.
Just because
you can.
You want to make political capital out of it and make that the selling point. And like for me, I think that one of the things is speaking to the ability, the humility, or whether it's practiced or honest. That allows her, and at the beginning of the interview, what she did was she was asked almost the same question like about 4, 5, 6 times about the shooting thing. And she was able to come back almost the same answer, but it slightly varied depending on what kind of style the question was, to say, look, this thing has been asked and answered. I am sorry. It's regrettable. It shouldn't have happened. The matter is before the police. And then you come back and ask the same question. What do you want? I should give you a different answer because
I should say no. Now the matter is before the local Mankralo.
It's moved from the court. So and again, when you set somebody up to fail, I wonder if that's also the purpose. I don't know if should that be the purpose also, to try literally to destroy the person's credibility. Does that inform vetting?
It's all fair game in politics, and I suppose if you're not achieving the purpose in one arena, you might as well try in another.
All right, so this might be the arena to try again. This is Asaase Breakfast Show. My name is Kujunansa. Her name is
Nanaya Mensah.
Basically, we're talking about vetting. I mean, it's an interesting word, vetting, isn't it? Like you're examining a piece of meat, vetting
You're,
it for
you're
cooking.
vetting, yes, a piece of animal, non-human meat. Yes. No, that's of course veterinary services. It's not the same thing. But yes, to vet.
Yes, to vet is to examine intensely, place under careful and close scrutiny, to dissect.
Well, we hope that they're not literally dissecting any of the ministerial nominees who've appeared so far, and that they won't be doing any of those to come either.
Well,
but it's right that people be subjected to scrutiny. I mean, I'm not entirely, I don't know that I have my mind made up about the point Dr. Antoinette Spudak was talking about earlier about whether the preponderance of time should be given to looking at somebody's track record where they have previously occupied the same portfolio. And what how much importance one should attach to somebody having been in the job.
Well, in that case, then the honourable former defence minister would never have gotten the job of defence minister, would he? I'm talking about Dr. Kufuor.
Dr. Adokufo, on the basis of him having been a doctor.
What's his track record in defence?
Well, no, but I was saying when somebody has occupied the portfolio previously, for example, people talk in the current government or the Akufo-Addo government Mark I about the particular cases of Dr. Matthew Opoku-Prempeh as Minister of Education, coming from a medical background, and what were his bona fides performing the job. But, most people would argue that he was very effective in the role, with the assistance of some very good people around him, of course. And, with Kweku Agyeman-Menu, likewise as Minister of Health, who comes from an accountancy background. So what were his qualifications for doing the job? It's a tricky one. I would like to think that if you can see that somebody has the competencies over and above their past work experience, it is about an ability to get a department moving coherently. It's about man management and woman management. It's about ability to marshal resources, and it's about this sort of relentless drive to bludgeon through with implementing
Which
ideas.
in Ghana, actually, is a good selling point. You see, that's the thing, which probably won't be exhibited at a vetting. But that ability that you just speak to, which is, where we live. This is Ghana. Quite honestly, Buklong will not get it done. So as we are just trying to be a little bit judgmental, Buklong doesn't get it done in Ghana. The president speaks to us and tells us, wear a face mask. It's compulsory. He finishes talking, and the guys who are watching the TV heard him say it. They go outside without their face masks. So it's not as if do you know what I mean? Then it goes down to, we are blaming the policemen for not implementing what the president said. Now, you need people who are implementers of policy, not strategists, not all the time, not in a Ghana. You need the bludgeon, the sheer force of will and leadership of, let's go into the trenches together. That kind of thing might just actually be what the president has seen.
Are you referring to your own management style here?
Oh, I don't bludgeon. I just beat to death. But you know what I mean?
I think, yes, I do know what you mean, but I think you have a certain bias here.
In terms of leadership style, yeah.
In terms of leadership style. There's some people who might argue that persuasive qualities and actually, the ability to do things in a wily manner.
Right, but that works in certain spheres of endeavor. Would you then say to me that you're going to be wily when you're talking to a bunch of fishermen at the beach? I don't think so. Wily will not work. Chobwe just might. So it's going to be different strokes for different folks. So
yes.
That comes down to the selection of who best fits this particular
role,
knowing the area you're going into.
And I think that's partly the problem, that in a sense the vetting committee, the appointments committee, has a certain style. It's not quite a one-size-fits-all approach, but there are certain boxes that they want to tick.
With the individual.
With every individual.
Yes, but are the vetting committee coming to the table and saying to themselves, look, this particular role, this particular ministry, it's not the minister, it's not just minister as a job description specifically that we want, but we're also looking at, for this particular ministry, this is the kind of person we need. And don't tell me that the Minister of Finance and the Minister of Aquaculture and Fisheries have to have the same characteristics at all. You know? Or economic planning or whatever.
That is the difficulty with the one-size-fits-all approach.
Okay, anyway, who are we? We're not the vetting committee, we're just here.
Oh, no, we're doing our own private vetting over here. In
We've been joined by the leader of the Justice League. He's straight off, just come out of his Action Comics debut.
Oh, dear.
We're looking for a different colored cape for him. So we're working on that transition.
With or without the mask.
Without a mask. We don't know. He might just be one of those ones who just comes with his face. He doesn't have to go into a phone booth to change.
No, to morph or anything. Just put on the cape.
Yeah, and he's good to go. Yeah. So he's here, and that's in the person of Dr. Kweku Ajiman Budu, head of law centers at GIMPA, and a lecturer as well, and also the founder and what is it? What's the other word I want to use? The leader.
The Gauleiter.
Yeah, of an NGO that's working on justice issues. It's called the Justice Foundation, and they actually do a lot of work on in a pro bono manner on defending indigents. And we learnt about the meaning of indigent the last time he was here as well. Persons who cannot help themselves in with legal issues and legal arguments and might actually get them out of the little bit of a trauma that they're in. And that's where the Justice Foundation steps in to provide that kind of support, legal assistance and legal support to persons who need it on a basis of free. No, we're not handing out his phone number. And if you do have problems with the law, go and settle with the lawyer. And no, that's not what we're doing. So anyway, good morning, sir.
Good morning.
Always a pleasure to have you here. I'm happy that Action Comics let you go for the day. Anyway, so boss, we've been following several issues, of course, over the last few days. You've been able to give us some, fairly regular updates. I want you to, before Professor Ransford gets here, I just want you to comment. We had Ni Papo on the phone, a lawyer, Samoa Ado. He was talking about the positioning of the petitioner. And before we get into what's going on now, his opinion was that at that moment, having already been rejected on the first applications, that the petitioner should just give up the cause. Now, I don't want you to opine, but simply in your own thought process, at what point would a lawyer say, you know what, this thing is not going to go my way, and then just give up?
I mean, so I don't know, and like you're saying, maybe we can't even delve into that because obviously we are not the counsel for the petitioner, so we can't take such decisions. What I can say is that even at this stage, we've come too far in the process to sort of back out somewhat. There has to be some conclusion one way or the other. But then again, I don't think it's going to be that simple for the petitioner to back out at this time. If you look at the Supreme Court rules specific to election petitions, yes, CI 74 provides the option or gives you an opportunity to withdraw the petition. I believe it's Rule 71A, but it is not automatic. You need to seek the leave of the court.
The same application process.
Backed by an affidavit. It can either be granted or it won't be granted. So it's not as though you can get up and say, okay, yeah. It's not automatic. It has to be an application for leave to withdraw the petition supported by an affidavit, and then the court will decide whether or not to grant, because basically you're asking leave of the court. So it's within the discretion of the court to grant you that leave or not. And so it's not, in my mind, straightforward that you would say I'm withdrawing the petition and that will be. It's on the basis of what the Supreme Court rules itself says. So it may be much more complex than just the petitioner deciding to withdraw at this particular point in time.
Right. Okay. I just wanted that opinion because I thought, okay, so and would it be the right thing politically, even for the petitioner to simply say I'm withdrawing, or would they want to see it through to the bitter end, not to waste anybody's time, but simply because we started a process, and in getting all of the rulings, it helps the process of the law going forward. Professor, welcome, and thanks for joining us. I don't want us to. It's not really an issue because they're not withdrawing. But it came up in another conversation. That's what I was asking Doc whether And I just wanted your thoughts on the opinion of somebody else as to they should just stop and let it go.
Why did that conversation come up? Why?
Because based on the rulings that had been given against the petition at that moment, they thought, no, this is not going to go anywhere. Let's leave it here.
Well, politically, it may be the strategy to use. I have always argued that the case that is being handled, they have two ramifications. See, there are happenings that can go on at the courts, and then there will be what would also go on in the court of public opinion. And so, which one are we interested in, or the petitioners? I mean, what are they interested? What is their interest? Last week, I argued that it will be that the case and the situation of the petitioner is so bad that there's nothing that can be done than for them to be serial losers in all the motions that they've filed. Or then there is something metaphysical going on that we members of the public are not privy to, regardless of whatever the situation may be. Like you're saying, I deliberately put that because I've also heard that school of thought that is saying that then you should withdraw. I mean, coming events cast their shadows. If all your motions and applications have been shut down right from the word go up till now, then you'll be unintelligent to assume that why you went there would be, or the kinds of demands that you're making on the court that led you to go to court would be granted. And so there is some wisdom in the call for the petitioners to then withdraw. I didn't know that you will still have to also ask permission from the court to go. But I thought people, if somebody wants to just be boisterous and awesome, just say, well, we came here and then we will leave. We will not even grant you the honor to vote or to give a judgment against us. We'll just leave. But the lawyer is saying that even if you want to do that, you have to ask permission. But I'm wondering whether the court would have the right to say that remain here so we give a judgment against you. I'm wondering whether that will be what they want to do. If they want to leave, I mean, they brought the case. They may be able to leave, but I don't know the strength of that particular provision that will so compel them that even to remain, even if they would want to leave and all that. But the processes are evolving and they are teaching us so many things about how the laws work and then how our electoral politics would have to be shaped, going on in future. So there are so many lessons that are being learned and all that. People are disappointed. Some people are also happy, and it is mixed. The way I see things, the outcome of the court process will still be like the outcome of our 2020 election process, where people who may even win may still not be able to overly jubilate. And those who may lose, in my view, may also not be overly rowdy. Let us learn about what is going on, and so that going forward in our future elections, let people be vigilant enough to ensure that everything works well. You see, there is a way it goes. If you are vigilant, and I am vigilant, and we are all policing the processes and all that, it compels the system itself to work. And all that. So I think there are so many lessons that are going on, and let's learn and then see how we can strengthen our electoral process, and let things be done in such a way that tomorrow we wouldn't have people brazenly telling us that, okay, we know the adage or the expression that elections are won or lost at the polling station. And so let us win it here, and let us not endeavor to go to court. Let us not get there.
Okay. All right. So let's not get there. Lessons to be learned from whatever transpires at the end of this process. The process so far. There's been a lot going on. There's been a lot of speculation about the way things should have gone, didn't go, and everything else that's gone on with it. In a potted nutshell, if you can, somehow, there's mixed metaphors there. Can we get a sense of what does all of this mean? What does it all mean? Where are we?
So we were drawn to the close or getting to the dying embers of the case, because you remember that so far, if we just do a quick recap, the petitioner opened his case by calling 3 witnesses who were examined, cross-examined by the respondents. And once they were done with their 3rd witness, the petitioner announced to the courts that they had closed their case. And so immediately they announced to the court they would close their case. It was custom for the court to call upon the respondents to then open their case. And that is what has brought about all the rancor that we have now, because the respondents, when called upon, also announced to the court that on the basis of everything that they have heard so far, and on the basis of all the evidence before the court, they believe that they would also close their case, and they would leave it in the hands of the court to decide on the basis of the evidence before the court at that time. So the first respondent announced that, and then the second respondent also said they also had no witnesses to call, and so they'd also close their case. And so that is what brought about this. So what happened afterwards was that once parties close their cases, it means we're heading towards judgment. And so the court, on the basis of that, gave some directions that the parties have to file their written addresses.
Yesterday,
2 days ago, and then yesterday they were supposed to come and give highlights of the written addresses, right, and the case will be adjourned for Judgment Day. But what then happened was that the petitioner or counsel for the petitioner objected to the respondents closing their case, that through statements that had been made earlier on by the chairperson of the first respondent in affidavits before the court, and also, even before the affidavits issue, that by virtue of a witness statement that the first respondent had caused the chairperson of the first respondent to issue, they had elected at that point to adduce evidence at all costs. So their argument was that by virtue of the fact that you have voluntarily written a witness statement, which has been served on all the parties in the case, doing so meant that when I closed my case, you would open your case.
You'd have something to say.
You would call that person to come into the witness box to testify. And that is what the respondents were saying. Well, we no longer see it necessary to call anyone to testify, and that we don't think you've even made any case for us to open our case in the
I'm going to
courts.
ask you a question again, though, and this out of fairness, this has always struck me. Look, if you give indication in your written statement or in your affidavit or whatever that you will be willing to subject yourself to cross-examination, just honesty, as far as I'm concerned, shouldn't that play a part in the decision then of the court that I said I'd be open to be asked questions?
Yes, and we'll come there because that's the second leg of the argument which we saw yesterday before the court. And there are two different rulings here, so it's kind of confusing if you don't take your time. The first one is what we're talking about right now, dealing with the respondents choosing themselves to close their case.
Right.
And the petitioner saying you can't do that because there are witness statements that you made which suggested that you were open, which meant that you had elected by virtue of the fact that you put in that witness statement, which has been served on all parties, stating certain things in there. It meant that you would give us the opportunity to cross-examine you as well. And also there are affidavits before the court in which the chairperson of the first respondent had stated clearly that the interrogatories that, you remember the issue of the interrogatories? Yes. That the petitioner wanted to serve on them shouldn't be allowed at that point because the petitioner will have the opportunity to cross-examine her if need be. So the issue now was the respondents are saying, yes, we filed a witness statement in compliance of the court order, but no, we have a right under the law to decide that we're not going to call any evidence because it is trite learning that a defendant in a case can decide not to open their case. They can even make a submission of no case.
Right.
Even. So what the respondents were relying on was the rules of court, CI 87, which is the High Court Civil Procedure Amendment Rules, which provides in Rule 3E of Order 38. It deals with witness statements generally. And so they were relying on Rule 3E, in particular Rule 3E5, and also Rule 3E1. And I need to take some time just so that...
You're going to abbreviate, please.
Okay. All right, I'll try to summarize. So Rule 3E1 talks about the fact that if a party has served a witness statement and that party wishes to rely on it at the trial, on the evidence of the witness who made the statement, that party shall then call that witness to give oral evidence unless the court otherwise directs. Then it goes on to talk about the fact that where a witness is called to give oral evidence, the witness statement will be deemed to be his or her evidence in chief. That is his testimony that he has given out. And then the other side gets to cross-examine you on the basis of your witness statement. Then, critically, Rule 3E5 says if a party who has served a witness statement does not call the witness to give evidence. Are you following?
I'm with you.
So, if a party who has served a witness statement, in this case, both first and second respondents, does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence. What that simply means is that there's the possibility, or the law recognizes the possibility, that parties who have filed witness statements may decide or choose not to call the witness to give evidence. So it's possible, and this is what the respondents were relying on, that on the basis of this rule, we are not going to call evidence. But the petitioner then was saying that no, by virtue of the fact that you served that witness statement, wrote it, filed it, you had elected that you would give evidence. And the respondents obviously grounded the argument on this. And the court ruled in favor of the respondents that indeed Rule 3E5 gives them that opportunity to decide not to call. Yes, and it is trite learning also that a defendant can decide not to call evidence, and that a plaintiff in a civil case or a petitioner in an election petition has to win on the basis of the strength of his case, not on the weakness of the other party's case. And they cited the 2012-2013 election petition.
This is going to become a rule of law, basically, for this.
It basically is
going forward. These
it is already before this time, generally speaking.
But now it's going to be reinforced by virtue of learning in the sense of what's happened. I'm just going to come back to you because there's more to it than that. But so far, Prof, and I'm talking again about the fairness thing, and I want to stick to that a little bit. It struck me. I was tired of the elections petition generally, but this struck me about, look, I'm really depending on the fact that you literally put yourself out there and said, oh, I won't answer the questions now. Later on, I'll put myself forward to be asked those questions. And in a commonsensical way, isn't that fair? Isn't that the way the justice is? And I don't want to talk about the law. That's why I'm staying away from it. But
you can't have this conversation without talking about the law. It's unfortunately...
The law is informed by common practice.
Precisely. But we made the law... Yes, but we made the law for us. And that's why the law is prospective, not retrospective. And the law has to be certain. So you can't, I beg you, I can't allow you to go on.
To ask a question.
No, not to go on.
Are you a host?
I'm not a host, but I have information.
No,
I can't allow you to ask that question.
I'm not challenging them.
No, I'm not saying you're challenging. I'm saying, I get what you're saying.
Yeah.
I get what you're saying. But unfortunately, there are certain things that is not just commonsensical.
Right.
You have to situate it within the context of the law. So you can't just say, isn't it fair? And it goes to a number of things going around, the public perception about the issue of accountability and
understood.
If she has nothing to hide, why is she not going to? Unfortunately, that is not the issue and shouldn't be the issue. I understand the propaganda value. And I understand the value of putting it out there.
I want to answer my question. I want to answer my question.
Please.
No, but you have to rephrase your question.
Rephrase my question.
Within the context of the law.
The context of the law.
So don't ask, I will respond. See, I think that there's been too much confinement to the principle of judicial restraints, sticking rigidly to what the law says. Okay, there are two sides to every coin. When I was in level 200, I was taught the principles of judicial restraint and judicial activism. When I was doing a PhD in the US, I took a course called Judicial Politics. And within these means of learning, I was taught that, yes, it is good for the courts to always stick to what the law says. But sometimes, he's a lawyer, I'm sure he took a course in what they call sociological jurisprudence. You must also be aware of the impact of judicial restraints on the society. So this is what the law says, this is what the law says, this is what the law says. Where are we going to provide the avenue for precedents to be set? That will in itself also become another law, case laws that can be referred to and all that. So all that is going on, my worry has been that it appears that there's been too many practicing lawyers who have now ascended, to the bench. And so they are confined to only what the law is saying. But you see, law is only one minute aspect of governance. Governance transcends law. And so you have to look at the broader, anytime you're talking, people come in, can I, you allow them a lot of, people come in to say that, but that is the law. That is the law. If you want peace, if you want things to be settled amicably, you don't always go to the courts of law, because in our judicial process is adversarial, and they will stick to the use of laws, and then they would also use strategies that sometimes may not necessarily may be used to settle a case without necessarily getting into the truth, but you get some justice and order. So, like you rightly pointed out, we all heard it that, at one point in time, you would have an opportunity to cross-examine one of the lead respondents. And I'm sure it went into the heads of many Ghanaians, including the petitioners themselves. Then, in the course of proceedings, you are told that even though we said you would have the opportunity to cross-examine, that opportunity you won't get an order. Naturally, people may be disappointed. And the disappointment sometimes may not only confine itself to the court, but it will go to the broader society within which we all live and operate. So when some of these things happen, it has its own impact and effect, on how people would perceive some institutions, of state within the, including even the judiciary. And so my worry is that, yes, they must apply the laws, but sometimes the principle of judicial activism must also come in, where judges or those interpreting the laws will say, yes, in this particular instance, if we adopt a strict principle of judicial restraint and say this is law, what will be the ramifications, on the society? I, in my ignorant view, feel that it would nothing may be changed, or it will still be in the interest of the election management body to be given an opportunity to even tell its own story where there were mistakes. Yes, we made it. It's a human institution. The petitioners, when they were filing their case, they made some mistakes. Okay, so it is in their own interest to even be given an opportunity to tell their own story where they themselves faulted and explain why. If you do that, you also create the impression that there's a human institution, it's also fallible and all that. It helps sustain people's confidence in that institution. But the way things are going, if you don't take care, it may be ingrained in the psyche that whoever gets the opportunity to be there as a chair of the election management body, you can go and do anything, even if you are wrong, you can still do it, and at the end of the day, even when you are taken to court, you would have a strategy to be able to get away with it. And that may be unfortunate. Yeah. And so my point is that our processes have been too legalistic, and they have not factored the impact of rigid confinement to laws to the broader, society. It's not everybody who is literate and knowledgeable about what is going on. So there are some sociological issues that, in my view, must come into play so that people would not continue to hold a certain perception about some of our credible state institutions that we have.
Right. Before I go to, because I know Kweku has got a lot he wants to say about this in response, but we sort of tackled this last week, so I don't want to go down this road too much. But here's the thing: you mentioned about her, the EC boss speaking to some of those issues, which are problematic. But is that the court for that? I mean, you come with an elections petition. Very specifically, you want to overturn the elections. What has that got to do with her failure to deliver in a manner and form that you wanted? She's a public servant. Is that the court that you take? Is that an elections petition anyway?
Well, there's been no opportunity for her to explain. Yesterday, somebody was trying to show me something. I think there were 6 different election results that were released. Mm-hmm. I mean, this came and I said, well, there's a mistake. This another one came in. I think if for nothing at all, the different election results that were declared, this is the opportunity that you see all eyes are on the processes, and everybody wants to hear something. So if we don't hear it now, when will people be interested in again? Right. We are in a period of election petition, talking extensively about the 2020 elections. Okay. So if you don't hear her talk about some of these things now, do you think that after the court processes are over, she goes to mount a platform and say, now I'm going to explain what happened? Won't people say that it's just an afterthought? Won't people say that she's taking the whole people, for granted and all that? So my point is, the judges, I don't think that they were wrong in whatever they did. I think that they did, or they spoke in strict law. But my worry is that the rigid application of only rules without daring to look at the societal impact of that legalistic attitude, may create problems for society. You may settle the matter in court according to law, but you may not be able to settle the matter outside court.
Okay. All right. Doc,
Yeah.
you've held your breath. Obviously you were talking about something, and I stopped you because I wanted to get a sense at this point, at that juncture, about the specific of the opportunity not being provided. So going on from there, where are we? I still want you to continue from that point.
I'll continue from there. But just a quick chip in here. I don't think it's fair to suggest that the court is being legalistic or has stuck to the strict embers of the law. I mean, the law is dynamic. The courts apply judicial precedent, but one fundamental quality or characteristic of law is certainty. We don't change rules when the rules have already been decided upon. And the courts indeed actually consider sociological whatever in making their decisions.
Sociological jurisprudence.
Yes,
I mean,
there
you
are
know
other
it.
schools of jurisprudence as well. There are several schools of jurisprudence. There's the natural law school, there's the positivist school of jurisprudence and all that. And we can go
But you
into
don't want
that,
the
which
common sense
provides
school.
that the law is the law, not what it ought to be.
Right.
Do you understand the difference?
Understood.
So if we as a people have come together to make laws to regulate a particular, say, area or a particular circumstance, it is not when there's a live case before the court that we try to espouse what the law should be. You understand the
So
point?
then when?
When? Afterwards, we don't change law. Certainty of the law is important. So, for instance, if you are, that's why retroactive legislation is prohibited. So, for instance, Parliament cannot make law today saying we are banning all persons from wearing checkered long sleeve shirts, right? And then come say yesterday, Professor Ransford Jampo was wearing checkered long sleeves, so we're applying the law to you to take retrospective effect. That doesn't even make sense. So you understand. So it is not when the case is ongoing that we proffer. I know, of course.
No, but you see, I respectfully disagree. When do we've had instances where the law says X, and then you've had judges looked at the law and say, yes, in this particular instance, given the circumstances around, we would have to find a way. And that has in itself going to serve as a precedent, and then people would be referring to. I think
true. And the courts apply judicial precedent all the time and make judicial precedent by their own
pronouncements and all that. Yeah.
But you see, it's a question of interpretation. So in the cases where the law may seem black and white, but the judges will interpret it, there's a principle of interpretation of law which gives, and that seems to be the dominant method that our Supreme Court currently is using, what is referred to as a modern purposive approach to interpretation, where the court, in interpreting whether there's a dispute as to the meaning of a particular provision, for instance, the court will look at, they don't just look at the ordinary meaning of the words in context,
as written,
but they would go, if the ordinary meaning of the words written will lead to, interpreting it that way will lead to an absurdity, they can go beyond that to appreciate or to look at the purpose for which
it was intended.
And so I'll give you a typical
the spirit behind the law. Yeah.
Yes, I'll give you a typical example. The Asaase and Attorney General case in the early 2000s, which had to do with President Kufuor's absence from Ghana, being deemed to be inability to perform your functions as president. So President Kufuor traveled outside Ghana, and the vice president, then the late Aliyu Mahama, also traveled outside Ghana. And under the constitution, when the president and the vice president are both absent from Ghana or otherwise incapable of performing their functions, the speaker is sworn in to act as president for that period that they are out. And so Asaase brought a case before the Supreme Court, essentially saying that it was unconstitutional for the Speaker of Parliament to be sworn in to act as president because he was the head of a different branch of government and was now acting in the capacity as head of the executive as well. And what the court did in relation to Article 60 of the Constitution, which terms are clear. It talks about absence from Ghana or for any other reason, and I want to actually find it. It says, yes, if the president or vice president are absent from Ghana or for any other reason unable to perform their function. So they now had to interpret that part, whether absent from Ghana, and that's what the court came to. Inability, yes. So the court said that with the words, the way and manner in which the words are framed, it says absence from Ghana or for any other reason unable to perform the functions, which means that absence from Ghana is one of the inability or one of the things that will make you incapable of performing your functions. And they went into a historical discourse about the essence or why the framers of the Constitution must have made absence from Ghana to mean inability. Because we know, for instance, that if a president travels from Ghana to the UN, for instance, to go to a UN General Assembly, the only reason why he's able to go there to represent us is because he's president of Ghana. But here we have the Constitution saying that notwithstanding, your absence from Ghana means you are incapable of performing your functions as president. Right. And so the court held in that way that the framers of the Constitution intended that at every point in time, there has to be an individual in Ghana who has subscribed to the presidential oath, who can take decisions if need be within Ghana. So that even though, yes, you are president of Ghana and you have traveled for whatever.
Acting as president in that capacity. Wherever you've gone to.
It still constitutes an inability to perform. Yes, there's been disagreements about whether it was right or not, but I was just giving an example to show that.
Localized. Okay, but so in that circumstance, and this is a pretty clear one though, this is where you're saying that when it's right and fit, the courts do adjust to show the purpose of the law, or the intent. So let's move on, because I don't want to dwell too much on. And I get that you have to educate in the way that you do. So it's and we thank you.
I just want to
thank you for that.
I just want to sum up my position on this. That I want to hope and believe that the case is still ongoing, and I'll call on the judges to use the opportunity to come out with judgments that will help fine-tune our electoral processes, rather than judgments that may ultimately then end up creating impunity among the election management some members of the election management body. Because if you don't take care, some people would erroneously think that if something go on wrong at our electoral, during elections, and you are not happy, just go to court. After all, if we go to court, we have we would even be prevented from answering or responding to questions about what we did wrong or not. If that happens, our electoral processes will suffer needlessly. And so I expect that they use the process to come out with pronouncement and judgment that will rather help, unearth some of the challenges of our electoral processes, particularly those that characterize the recently held elections, and then will serve also as recommendations that will help us fine-tune the processes.
Okay.
Very key.
Right. Before we go to the break then, Doc, I'm just going to let you conclude on this elections petition. So where we are, I want to get to where we are now.
Yeah.
And what are the next steps? Okay.
So the next thing, or what happened yesterday, was in relation to what I had talked about earlier on, about the ruling the court gave, basically affirming the right of the respondents to close their case. And so the petitioner applied for a review of that ruling, that on the basis of the certain grounds that there was a miscarriage of justice. And one of the grounds the petitioner strenuously argued was that the court had given that ruling per incurium section 26 without regard to section 26 of the Evidence Act. And section 26 of the Evidence Act talks about the fact that if you make a statement or you do something that leads someone to rely on the truth of that statement, you are stopped. You cannot turn around to resile on that statement that you had made someone rely on the truth of that statement to act in a certain way to that person's detriment. So
they were telling the court that they could not allow the respondents to close their case.
Yes, that the court had taken the decision allowing the respondents to close their case without having regard to that provision of the...
Understood.
So essentially, a miscarriage of justice had been occasioned. And all the grounds, there are about 5 grounds or so that the petitioner put out there in terms of the review, because in order to invoke the review jurisdiction of the Supreme Court, you need to show one of 2 things. Either there are exceptional circumstances that has led to a miscarriage of justice, or that there has some new evidence which, with all due diligence, you couldn't have discovered at the time of the initial phase when the ruling was being given or when you were making your arguments.
Right.
So if something subsequently comes to light which would have impacted one way or the other, and through all reasonable diligence you couldn't have gotten it at that time, that will constitute the ground in which you can invoke the review jurisdiction.
And that would have definitely made a difference to your case had it been available to you prior to.
Yes, and the petitioner was going under the ground that there were exceptional circumstances that had occasioned the miscarriage of justice, one of them being the Section 26 issue. And they talked about a number of things as well, including the court's ruling being in error because they failed to appreciate the constitutional role of the electoral commissioner, the court being in breach of Article 1913 on fair trial and Article 296 of the exercise of discretion and all that. But the court's ruling essentially reaffirmed its earlier ruling. What the court said was that because the petitioner was arguing that the court, by not referring specifically in their ruling to Section 26, had acted contrary or had given its decision without regard to the law. But the court's ruling was to the effect that they were not persuaded by that argument, the issue of statutory estoppel, that simply by not referencing that particular provision did not mean that the decision was per incurium. And if you read Section 26...
You can tell me what per incurium is before we go to the break.
Per incurium is without regard to the law. So if a decision is taken per incurium, it means it was taken without having regard to a provision that probably is controlling of that particular issue
at stake.
Yes.
Okay.
So the court basically made a mistake, didn't avert his mind to...
No due diligence.
Yes.
Was slovenly and slothful.
Basically, yes. But if you read Section 26, what has become controversial now that a lot of people are talking about is on the issue of you making a statement and somebody relying on it to that person's detriment. It begins by saying, except as otherwise provided by law, including a rule of equity. Except as otherwise provided by law, including a rule of equity, which means right from the beginning there are exceptions to the rule. When a party has, by that party's statement, act, or omission, intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon that belief, the truth of the thing shall be conclusively presumed against the party, and so on and so forth.
Right.
But critically, it says, except as otherwise provided by law,
Understood.
including a rule of equity, which means that there may be other laws that provide exceptions to this rule. And one of such laws is CI 87, which provides that it is possible for a witness to have served a witness statement but decide not to call the witness to give evidence at the trial, or it's possible for a witness to make whatever averment or whatever it is, and then
not be bound
still
by
not
them.
precisely the point. So that may be the basis, and the argument now is Section 26 is of the Evidence Act, which is a statutory provision. It's an act of Parliament, basically speaking.
Right.
So will an act of Parliament supersede a subsidiary legislation, which is CI 87, which is in the hierarchy of laws, is subsidiary to an act of Parliament. But the act of Parliament doesn't specify the types of laws. It even says including a rule of equity. And the rule of equity is equivalent to the common law, case law, judicial precedent, which is also subservient 2 acts of
Now you're
parliament in the
becoming too
scheme.
technical, and most of my listeners, like myself, will be. I'm following.
In simple terms.
Yeah,
in simple terms.
No, I'm just going to need to go to the break. In your simple terms, they're not simple.
Yes, in simple terms, real simple terms, the act of parliament is here. Other laws are below that. CIs, LIs are here, are below acts of parliament.
Okay, so
but the act of parliament is saying that except as provided by any law, including rules of equity, a rule of equity, which an equity, just like common law, is also below an act of parliament,
right.
which means that the CI being below an act of parliament can also provide those exceptions that the act itself recognizes. So that may be the basis for the decision that way, that indeed the respondents were within their rights to close their case
at the time
that particular point in time.
Without
but then, without calling any witness, yes.
Okay.
But now the thing is that the next step is what we saw happen yesterday was the petitioner also saying they're applying for a review of the ruling that was given in relation to the court dismissing the application for them to reopen their case. So that's 2 different things altogether.
Understood.
We've dealt with the one about the respondents closing their case and not calling evidence, and the court has dealt with the petitioner trying to reopen their case to get a subpoena to compel the chairperson of the EC to testify. And that is what the petitioner is now applying for a review of that particular decision on Monday. So that is the stage at which we are right now.
Okay. All right. A lot in there. And again, because of the issue it's specific, we do have to get a clear picture so that we are not involved in the speculation around the law that we really don't have a handle on. That's why sometimes we allow, we actually let the law lecturer have his way. Sometimes not have his day. We're going to take a break. When we come back, though, we're going to talk about some other issues around the law, but more in a social context and other things that have gone on. Too made some statements, and his party decided to pull him up for it. I'm talking about party discipline generally, just as a curiosity. Muntaka made some statements. He's been hauled before the court for contempt. And all these other things that are going on around statement making generally, statement making and the dangers involved in that. I want to get some sense from our governance gentlemen here about these kinds of things and whether or not institutions must be more strict on that kind of thing. I'm just curious again. Of course, there are specific issues that we do have to talk as well. COVID-19, vetting of ministers designated by Parliament's Appointments Committee, and other issues that come up. That's after the break.
Town Hall Talk on Asaase Radio 99.5. Informed questioning, researched analysis, issues-based discourse, and insightful conversations with leadership. Town Hall Talk is on Fridays from 5 p.m. with repeat on Saturdays 7 a.m. to 8 a.m. on Asaase Radio 99.5. From public, private to corporate, academia and technocrats, Kofi Aboche puts authority to text and query and assesses Ghana through all forms of leadership. Town Hall Talk with Kofi Aboche is also streamed live on AsaseRadio.com and on Facebook at Asaase Radio 99.5. You can join the conversation on all social media, Asaase Radio 99.5, and on WhatsApp 020-0000-995. Town Hall Talk, where the voices of our land highlight the topics that matter to you.
From oil to gas to hydro to renewables, it is all about energy. Energy, the power behind Ghana's development agenda. Energy, the driving force behind the nation's industrialization. Energy, without it, the country cannot move forward. Every Monday, between 7 and 8 p.m., join Emmanuel Abuajiweafe for Energy 101, where you and I learn about our energy reserves, new initiatives in the field, the challenges faced, and how we are managing our resources. Energy 101 brings you an in-depth look at how Ghana is building its energy capacity, developing new sources of energy, and how we are managing our energy. Every Monday between 7 and 8 p.m. Tune in to Asaase Radio 99.5 for Energy 101. Our future, our present.
Wash your hands, sanitize, mask up, and keep your social distance. Abba, be safe, so all of us go fit be safe from corona.
A public service announcement from Asaase Radio.
Is our country being governed by national interest policies or on mere political sensationalism? Are our statesmen living up to their promises captured in their manifestos? Are these policies being implemented indeed for the people? And do our leaders pay attention to the generation they call future leaders? These questions and their like are those that we find answers to on your late-night current affairs show, Candid Voice. On Candid Voice, we talk facts and we speak truth to power. Join me, Benjamin Ofeado, this and every Sunday night at 9 p.m. on Asaase Radio 99.5 with my panelists as we discuss the matters that matter to you. Candid Voice, as it is.
Asaase Radio 99.5.
Ye fitu abodom be capital town e chini Banko Kumasito be Koti Congress. Ye fitu abodom be capital town e chini Banko Kumasito be Koti Congress. Ye fitu abodom be capital town e chini Banko Kumasito be Koti Congress. Atie bi tum be faso yo Banko Kumasito be Koti Congress. Atie bi tum be faso yo Banko Kumasito be Koti Congress. Hey, hey, Bankuto, that's sorry. Hey, make Kumasito. Hey, Bankuto, that's sorry. Hey, make Kumasito. Hey, Bankuto, that's sorry. Hey, make Kumasito. Yeah, mama, money tie, I can say a fam na masugu sway. This is a true story, and I see some show. That's right. I just cheer for beef, yes, and tea, man, move patrad, yeah. Man, you not have the sour, dear.
So anyway, let's just talk about this very briefly. At 9:25, our guests are still here. Professor Ransford Van Jampo is here, and Dr. Kwaku Agyemang-Bodu. And we've been talking at length about the legal issues around the Supreme Court petition. There are other issues, however, and one of those has been a statement which some might find just normal, others might find a little bit offensive. If you're a big boy on the bench, you might consider it extremely offensive. Predetermined agenda was a phrase that was used to indicate that Asemno is going the way as predicted. Predetermined agenda, a little bit offish if you speak the English language well, and you might actually be always interpreting the English language, then you might find it extremely offensive if somebody says you have a predetermined agenda. Anyway, Mr. Dominic Ayine was cited for contempt by the justices, and it appears that the matter will be going through Parliament. And I want to get a sense of, predetermined agenda is just language in the heat of the moment. We've heard descriptions such as, Beshi? Language of Beshi politics. And at that moment, you just got a little bit mad. So are we to put it down to that, or should we take it very seriously?
Yeah, I have also not been happy with the way, like I've always said, the Supreme Court judges have confined themselves to only the laws, and they've been doing what we call judicial restraint and all that. I'm not too happy about that. But there's a way to articulate some of these. The Supreme Court justices are not immune to criticisms, and their judgments cannot be swallowed hook, line, and sinker, particularly if you disagree with them. But there is a way to articulate your disagreement and displeasure in a manner that will not scandalize them, or in a manner that will not sort of openly disrespect the authority that they wield. And so, for me, I was quite surprised that boldly there was that sentiment expressed that they appear to have a predetermined agenda. I thought it could have been couched, to say that they have predetermined agenda suggests that then you have a certain information and knowledge and about that, and you can justify or you can explain yourself away about that. But when I heard it, I was quite surprised, but I didn't delve much into it because it was coming from a lawyer of many years,
no mean repute,
of no mean repute and all that. So there's been several critical things that I've said, but before I say them, I bounce them with my lawyers, ask, will this amount to contempt? And I get a clearance first. Sometimes they tell you, tone down on this. I said, okay, because I still want to speak my mind without necessarily disregarding or disrespecting our justice or our judges and all that. And so when he came out with that particular statement, I thought it was too harsh. But again, I felt that he's a lawyer. He knows what amounts to contempt and what amounts to genuine, honest criticism and all that. So maybe he may have covered his butts or something. But like you said, even though he's been cited for contempt and he's been invited, he said, I think still in the way and manner things are done, especially if you are a member of parliament, you cannot just be hauled before a court. You have to do so through the legislative arm of government, and so he's a member of parliament, and so I'm told he's asked that the invitation be voted through parliament. I'm sure parliament would also want to. So it's going to be a kind of tug of war between these two independent arms of government. I'm sure parliament would also want to look at the matter, and there may be some form of flexing of muscles. It may not be easy that he will just maybe Bama Kukwe, when he was a speaker, did that a lot. That he insisted that such invitations and all that should be routed through his office as speaker and all that. So I am not too sure that it will be very easy for that invitation to be honored and all that. It would have to. There will be some flexing of muscles because he's also a member of parliament. But I must also say that being a member of parliament should not grant the license for anybody to malign our courts. Like I said, I will say it and say it again, that I'm not happy with the way things are going. But that can be kept at the level of my opinion. Opinions are like Moses. I will speak my mind, but we have to be careful that in trying to speak your mind, you don't say things that sort of would take away all the public confidence and trust in the judicial arm of government, and also descend down into the gutters of insulting them. If we all want to be doing that, then at the end of the day, I've always said that it appears that it's only the courts that we have to arbitrate, in some of these matters. And given the public perception that now people have about them, if you add insult to what is already going on, then we may be destroying that institution too. And I don't think that it's something that we have to encourage. And so let's see how it pans out.
Right. I'm going to come to Doc because I want to get a clear indication of what constitutes acting when there's a phrase in English law that they used to use on a frolic of his own. The gentleman was, at the time of making the statement, bouncing around as one of the legal counsel and members of the team.
It depends on how he proves it, because there is always a hazy line that tells when you are acting as a member of parliament,
right,
and then when you are on your own.
That's what I'm going to ask you if I go to Doc. Is what I was going to ask you. Though. Is this cloaking yourself in the protection of an institution when you've done something wrong? Should that not be challenged?
The history of the Fourth Republic does not really tell us more about this, where members of parliament have done something wrong and they've been given out that, look, you are not a member of parliament at this particular time, especially when it comes to invitations by the police and then also invitations by the court. We've not had a lot of examples. So, but like I said, there are times that it becomes difficult to determine at what point in time was he acting as a member of parliament and at what point in time was he on his own. But take note that even if he can claim that at all particular point in time, at every moment he was acting as a member of parliament, it will still have to be up to parliament itself for them to say that no. There will be some adjudication to say that no, at this particular time you are on your own and order. So it will not always fly for one to argue that at every point in time I'm a parliamentarian, and so even if I run afoul of the laws of the land, I should be left off the hook. There's no law that says that a member of parliament cannot be disciplined or punished when he ran afoul of our rules and order. So I want to believe that Parliament will look at it. If the letter is rerouted through them, they will look at it and then they will know what to do. But generally, regardless of how you feel about a court decision, I think the way to go is for all who feel bad about it to exercise some level of emotional intelligence so that you will be able to pour out what is on your mind, but you do so in quite a mature way so that you may not be seen to be contemptuous of the courts.
Right. Doc, there's a few questions in there. I think you got the sense of what I was saying, but also addressing what Prof has said.
Just to preface what I'm going to say, I think the problem lies squarely at the foot of the politicians and the political parties in Ghana. And I quite remember last year, somewhere towards the end of the year, we're having this discussion here about political talk and the fact that people can make statements on political platforms and get away with it. And it's like, oh, it's political platform talk and we don't seem to do anything about it. Or it's become sort of the norm in Ghana that politicians can get away with certain things they say once it's on a political platform. And it seems to have been generally agreed by all parties that we can say certain things and don't really mean it and things of that sort. I think that is the root cause of the problem. And clearly, both parties in this particular case, I mean, although it's individuals that are before the courts, but they are backed by parties. The NDC and the NPP are fighting a public relations war in the proverbial court of public opinion. And especially the legal spokespersons of these two parties, who themselves are politicians and double, or they are lawyers and double as politicians, they must at all times in communicating to the public or to their supporters or to the general public, be mindful of their duties as lawyers, which include their respective duties to the public and to the court, which every lawyer is aware of. And these duties imply that when you're making pronouncements, you should at all times be able to distinguish between law, that is what is applied in the courtroom, and political talk, which we seem to have agreed that you can say anything and get away with it because it's political talk or whatever it is to rouse your base and things of that sort. But you should not be prejudicial in your statements. And the fundamental difference between what Prof was saying about criticizing court decisions and judgments, of course, nobody has said you can't criticize court decisions. They criticize it all the time. Yesterday, we heard counsel for the petitioner talk about the fact that there are numerous professors and scholarly persons and other persons in general who have vehemently criticized court decisions in publications and all that. It is allowed, but not when the case is ongoing, in which you are a party to one way or the other. You don't make prejudicial statements. And I'm not saying whether what he said was prejudicial or not. Obviously, the court believes that it may be prejudicial, so that's how come summons have been issued in relation to contempt and all that. But my point is, in making such statements, when you are a politician and you're a lawyer as well, because unless, of course, you've decided no longer to be a lawyer and you put down your tools or whatever it is, for all intents and purposes, you are a lawyer, you may be of good standing at the bar and all that. You must be aware of your duty to the court. because you can't scandalize the court. And this is something everybody knows. This is something they teach in advocacy and legal ethics. You must appreciate your duty to the court, to uphold the image of the court and not denigrate the court. That is fundamental. And that's why I was saying that I believe that it is at the doorsteps of the politicians themselves, because they have sort of blurred the lines because of the political nature of the case itself. And everybody appreciates the fact that the case is political because it emanates from a political activity, the elections that were held. But you still have to be aware that the Supreme Court is the forum where the matter is being adjudicated. And so your comments should follow the law. And in fact, as a matter of fact, I think that the worst thing or one of the things that has been bad about these proceedings is the press conferences that are held afterwards. I think they are needless.
The justices have spoken to specifically.
Yes.
Spoken to.
Yes. I mean, they didn't say you can't have that. They just said that you should the content. But I think that it wasn't. I mean, they could have press conferences, but probably shouldn't even have been within the precincts of the Supreme Court. They could have been done elsewhere at the party headquarters or anywhere else you choose to do it. Because, I mean, immediately after the hearings, tensions are high. Parties or the spokespersons are likely, or sometimes they say things off the cuff and not necessarily twist things to suit their particular political position and things of that sort, which I think it's not good. And it's about time that we need public education about what is actually happening in the court and not rely on what the parties are saying. But unfortunately, the media, including Asaase Radio and all the other, are interested in the statements that will be made after the court, because that has the sound bites, that has the headlines, but not necessarily educating the people as to what actually transpired. But how many people understand? We've just said here that people generally
blame the media for that.
No, I'm not blaming the media. I'm just saying I'm not blaming the media.
I need for you to conclude on this.
Yes, I'm concluding. And my conclusion has to do with I'm not blaming the media.
No. The shielding. The shielding.
You know I was still referring to it before I answer the question.
The cloaking myself in the permit of Parliament. Where's the defense in that? When you make this, that's where I asked the question: was he acting as who was he?
Okay.
At the time of making the statement.
Okay, so before coming to who was he at the time of making the statement, back to what I was saying.
Time, please.
So you're gagging me?
Yes, I am.
So who was he? He was a member of parliament representing his constituency at that time. You can't take that away from him. He was also a legal spokesperson for the petitioner in that particular case. So at that material time, he may not have necessarily been acting as a member of parliament, but he was acting as a legal spokesperson. But that does not take away the fact that he was a member of parliament at that material point in time. And we know that the Constitution, I believe in Article 118 thereabout or something, talks about immunity, or is it 117 or 118? Immunity from service of court processes when Parliament is in session. So if you can't serve court processes or processes emanating from anywhere outside Parliament or the Member of Parliament when he's attending at or returning from or something of a session of Parliament. But yes, so that is clear. There's the immunity there, but whether it's a substantive immunity in the sense that they can't be brought before the court, I doubt that is the case. It has to do with when they are attending at proceedings of Parliament. And the Constitution itself also gives the Supreme Court the power of contempt in Article 1912.
Supersedes the power of
I'm not saying it supersedes, but they also have the power to commit persons for contempt to itself. But what I'm saying is that there's immunity for members of Parliament when they are attending at or doing things in relation to sessions of Parliament. But that does not mean that you are shielded as a substantive immunity like the president has, where he can't be served or sued when he is in office.
Okay,
that's the fundamental difference.
So there are if you're not acting on behalf of Parliament or going to from, then you can be served with.
Yes.
And again, that would apply also if you went and committed murder. You couldn't say, I was, at the time of the killing, I was a parliamentarian. Now, gentlemen, both of you, I want your opinion. Is the Supreme Court should it take action like this, these contempt actions? Should it just ignore them and treat them as mosquitoes, or must it take firm action to stop this kind of thing? I want a sense from you of that.
Well, I think that for me, I would wait to see whether Ayini would actually appear before the courts before I can make my take on this, whether I should take action or I shouldn't take it. Because I have a little belief that there's going to be some flexing of muscles, particularly given the kind of parliament that we have. That is a hung parliament, a parliament of equal strength, and a parliament that has the speaker being a member of the opposition, quote unquote, opposition party. I think there may be some flexing. There will be flexing. There will be flexing of muscles in a manner, in my view, that may not land. I said may not land Ayini, even before the courts for this matter to be heard. So I am a bit skeptical. He knew what he did when he said, reroute this invitation through Parliament. Okay, but like I said earlier, we don't also want to encourage the fact that because you hold a certain position, because of certain privilege you have, you can just say anything. I mean, that one, I don't also want to subscribe to that idea. And so I'm fine. Like he said, the Supreme Court is clothed with powers to summon people before them, to trial them for contempt. But Parliament also has given some immunity. The Constitution, again, also gives immunity to some to members of Parliament, in trying to summon them to before the courts and all that, when they are going and then when they are coming. Okay, when they are on their way to Parliament, and then when they are coming out of Parliament, and also when they are in Parliament. So we will have to determine where he said what he said. Was he on his way to Parliament? Can he say that, well, I was going to Parliament, I was going to Parliament and they stopped me to offer my view, and then I gave my view and then drove to Parliament. And all that. So there would be there will be interpretations and all that. And so my point is, and these are some of the things that I expect that we will all open our minds to. You see, we are now in a very polarized society, and there's so many things going on. And I expect that the processes, the court processes, would also look at, you see, lawyers like my colleague, I mean, they are just looking at the law. It is the law. It is the law. I don't go to court. So, I mean, he's, I'm sure, spending most of his time studying what the courts that have been doing and then goes to court. We don't go there. And we know and better appreciate what is going on in society more than people who are always in the courts and all that. So sometimes when we are saying some of these things, we also mean, well, we want the case to be resolved, the matter to be heard and verdict given in a manner that would ensure that even those who lost, they will say, you saw what happened during the 2013 election petition. After the ruling had been given, the one that lost said, we are grateful. The one who won also said, we are grateful. And I was surprised, said, but you lost, and then you were...
But that's just normal.
That's just normal.
Well, but to the court, yes. But in the court, of course, they have the standard.
Yeah, but even if you notice in the rulings, immediately the court gives its rulings, the ones that go in their favor say, we are grateful, my lords. And the petitioner says, as you please, as your lordships please.
Yeah, but in 2013, they all said, they all said they were grateful to the courts.
It's not necessarily that they were happy with the decision.
Yeah, I know. Yeah, but I'm saying that. But at least, you see, it's not. You see, the point is the effect of what they say or their action or reaction to some of these judgments goes a long way in affecting how people behave or conduct themselves, in the society.
Right.
So I'm saying that when they both, the counsel for the petitioner, counsel for the respondent all got up to say we are grateful. It in its own way had a certain impact on the broader society and their followings and all that. So I am saying that, are we going to get to that situation again with this particular case where after the judgment, even the petitioner, counsel for the petitioner would say, yes, we are grateful, and then same would go for counsel for the defendants and all that. We'll have to be inching closer towards that, and otherwise, like I said, what is going on has a lot of implications for what will happen in society afterwards. And nobody should only focus on law and be overly legalistic to the point of ignoring what is also happening in society.
I disagree very much.
No, we've always disagreed on this. I do not expect you to agree with me on this. This
because the court also has to decide on the basis of the law, and there's no way in an adversarial system two parties will be happy with the decision of the court. And like I was saying, there are different ways of getting, if it's accountability that you want, you can get it. But in terms of going to court for the specific purpose, as you put it, of overturning an election result, that's the bottom line. We should look at,
is it overturning or rerun?
Basically, because you have to overturn it. Overturn the result. Because the result was that
you can rerun it is to overturn
more than 50%.
You may keep the status quo and rerun to see whether
they're asking for a rerun of the entire election.
Okay.
Which means that the results should be overturned.
Okay.
And so it has to be based on law.
All right. We don't have too much time, gentlemen, but somebody, Kojo has pointed out, and I'm
going too fast.
Doc, address this. Enoch says, remember that Parliament has been suspended for 3 weeks. So at this moment in time, there was no Parliament for Dominic Aine.
The appointment committee is still working.
But Parliament was suspended because of COVID.
Yes, but you see,
appointment committee is
vetting. I know. It's a committee.
But there could be other committees also.
Yes, so Parliament.
Yes, but it says
Parliament is made up of committees.
I just want to know what the
definition. Yes, but Article 117 says this: that civil or criminal process coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member or the Clerk of Parliament while he is on his way to, attending at, or returning from any proceedings of Parliament.
Any proceedings.
Gotcha.
You get the point?
Yes.
So it doesn't say you cannot be served, it can't be served on you. But it can't be served on you when you are doing any of these things, if you are attending, which could include committee meetings. We don't have any idea of the other.
No, maybe he's sitting on a committee somewhere that we don't know
Precisely.
about. Or he's doing by Zoom. Okay, understood. So I just wanted that clarification. And I do have to rush us because we haven't talked at all about the vetting. So we're going to spend like 2 or 3 minutes each on that one. Prof, I'll start with you again. You can do an overall, if you like, of what you've seen. And one of the things that we've tried to talk about is whether or not we've seen a political bent towards the way the thing has gone. People just trying to embarrass people. And are we actually getting the best from our vetting process? What are your thoughts?
Well, it's been a polarized process. Questions that have been asked, some of them have been abysmal. Some have been questions that you have just thrown at the nominee, aiming to elicit information you know or the nominee already has a firm grasp over and all that. These haven't helped. The opposition have been critical. The members of the minority group who are serving on the committee have been critical. Members of the majority group, I'm saying this advisedly because of the way the speaker gave his ruling, because I still insist that it's a hung parliament. So members of the majority group have always asked questions that have, in my view, just giving opportunity to nominees to shine. It's like throwing the ball so that they will chest it and then play totals with it and Dangoshi and all. So I've found it a bit worrying. Why? I mean, if the person is good, the person is good. And so I expect both members of the minority group and members of the majority group to ask well-researched questions that would elicit what we are looking for from the nominees. But so far, it's been business as usual. It's always been the minority that is always grilling, and sometimes also overly doing things. And then the majority, members of the majority group, also asking just questions that are aimed at assisting, especially if you have not done so well in responding to questions from the minority group. Then they come in to do some damage control by asking you questions that they know you can clearly answer. Let me say this. If I don't say this, I wouldn't have just done justice to my own self. Let me say, I've been talking about the use of the military, the civilianization of the military. When Godfred Odame was being vetted, yes, he's a brilliant person. To say he's a brilliant person is an understatement. Everybody knows. Before he became an attorney general, we know of what he was doing. And as deputy, before he became a deputy attorney general, we knew, his prowess and all that. As deputy attorney general, we know what he's been doing and all that. So for me, I have no problem with him. But having answered all the questions and all that, then you have my own friend, Afenyo Makin, coming in to bring in, I've forgotten the provision he quoted, but a constitutional provision that says that. But there was a question that sought to find out who was guarding him as by way of bodyguard and all that. And we know that's a soldier, but he didn't want to give that answer. Then Afenyo Makin comes in to quote a constitutional provision that says that the soldiers are supposed to be defending the territorial integrity of our country, but beyond that, the president can also determine what they have to do. So it's like quoting that provision to sort of justify the fact that some people can have soldiers bodyguarding them. But I've always said that, you see, when we were drafting the 1992 Constitution, the Ghana Bar Association boycotted the processes. Okay, it's the ordinary tailors and hairdressers and beauticians and all that, ordinary people who actually put the Constitution together. And they always know the spirit behind every provision. Okay, so the spirit behind the provision he quoted was for soldiers, in my view, to be performing their role as soldiers. Yes, it is in the Constitution that the president can also decide whatever task he wants them to do and all that. But I doubt that those who framed that particular provision meant that soldiers should be used anyhow domestically, or we should civilianize them and all that. So generally, this is just an example of some of my reservation of the members of the majority group asking questions that sort of damage controls whatever responses that may have been given by nominees that may not be too good and all that. And
should have been queried a bit more,
yes,
thinking.
I am hoping that we would be able to have all the sides coming together and then grilling and then eliciting better information from nominees in a manner that ensures that whoever is selected and approved would have the support, the true support of all members of parliament. That said, I've been told that no voting has taken place on any of the nominees yet, and I want to hope and believe that the fact that some have answered questions does not mean that all who answered questions would have to be okayed. It should be possible for Parliament to play its role as countervailing authority to the powers of the executive, and where they feel in their own mind that, look, this particular nominee shouldn't go through, I expect them to boldly say so, that this particular nominee should not go through. Because frankly, listening to them and watching them, not all of them should sail through as appointees.
Right. Okay. That would be an interesting new twist to vetting if some people get rejected.
When this happens, it doesn't shortchange anything. It simply is saying that, Mr. President, you may have meant well, but this particular nominee is not again. Just bring in another person.
All right.
That's important.
Let's hope that we will treat it in that spirit. And if we can treat it in that spirit, then it's not a bad thing.
But then let's ask ourselves the question.
Your thoughts about this, please.
Which begins with a question: when have we ever had that type of vetting that Prof is referring to? It's the same thing over and over again. The majority or the minority will always ask the critical questions, and the majority will throw the softball questions.
But that doesn't prevent us from saying it ought to be.
I'm not saying it prevents us from saying. I'm just saying that what you said about this particular vetting isn't necessarily new. It's something that we've seen over and over again, and no one can deny that fact. So maybe, yes, what you're saying now is that we should look beyond that partisan sort of vetting that we've had and have a vetting that is critical, that both sides throw questions, because at the end of the day, they are there to help the president appoint ministers who will be able to fit the bill and prosecute the agenda of the president in question. But to simply suggest that the majority group are throwing softball questions to the nominees to sort of counter the critical questions of the minority will not be doing justice to the history of vetting itself in this country, because it's been the same over and over again. That's simply the point that I'm trying to make. Not to suggest that it should be that way, not to suggest that we can't think of a way in which we will have a vetting where it will be critical all along, but just to point it out that this is what we have seen. And so I don't think anybody should be particularly surprised that that's how it's been going.
Right. Okay. That having been said, but we're not. I'm going to then. You see, some people you let Godfrey talk for 6 hours, and then you decide you're going to set up rules that limit a question time to 2 hours. Is that a little bit unfair? And what does it say about the vetting committee itself and its slovenly and slothful approach?
Well, I think that maybe they were listening to some of us that it was needless for you to subject.
Prof, you cannot tell me that you didn't know before this thing started there. Sitting somebody down for 5.5 hours was going to be
so I'm saying that when we saw some people sitting for 5 hours and 6 hours and all that, we started wondering, look at the number of ministers you guys are going to be vetting. If they are all going to be doing 5 and 6 hours, then we'll vet in perpetuity. So maybe they may have listened and all that. But the point I want to still make is that, you see, there is always a tendency for us to make statements that sort of encourages certain needless norms that we've cultivated in our body politic to perpetuate. So, for instance, the comment that, but they've always been doing this every time, every now and then. Majority side would ask softball question and minority would ask. I mean, it's a comment that, in fact, does not really encourage.
But is it not true?
It's a comment that does not encourage people to really want to set up to ensure that they do the right thing. Okay, so the practice of looking at disingenuous practice that have occurred over a long time and just pandering to it to say that, well, but that's what they've all done, in my view, does not help advance our efforts to ensure that we make progress by looking at the past. But you see, you copy what is good about the past.
Yes, but then
practice of looking at bogus, disingenuous practices and using that as something of legitimizing what is wrong now.
Okay, that's something new that came all of a sudden.
Understood.
It doesn't make us a thinking society.
Yes, but then in a thinking society, we look at the past
and look at
how we consider the context and not make statements that make it suggest as though all of a sudden this new trend has happened. We need to look at it within the context of
what you're both agreeing with each other.
To look at what is at the past that is bad.
It actually is forward-looking to look at the past within the whole context of both good and bad and fashion a way forward. Not to simply isolate this situation that this Parliament Vetting Committee is doing such a bad job, that the majority is asking questions that are softball.
You want to say that it's always been the case.
It's always been the case.
It's always been the case. That doesn't mean we shouldn't think.
Yes, and I said our views about that we should look at it to look forward into the future.
Gentlemen,
please, I'm not talking enough.
Gentlemen, I think that the problem here is that in general terms, you agree with each other in the simple specific that this is a practice that has repeated itself. Now, I think that in conclusion, we can say that it's been done, and it's not a good habit. It doesn't all go well for us. But we must learn both.
Precisely.
It's because we know it, that has been something that's done. That's
Yes,
why you've
but we can't put it in the back burner as though it's
no,
something
it's not
new.
because he brought it up.
Yes, but he was suggesting that it was as though this whole.
I think that's the problem is where you're coming at the same thing from just different aspects of life, and I beg you not to think that I can interpret your brains because I can't, but I just think that that's where you're coming from. So I want us to leave it there on that very not heated but exciting note. Leave it there now. I asked the question, and I'm still asking that question before we leave. Please, Dr. Kweku, the 2-hour limitation that was placed after they had started the process by allowing 6 hours, that was the question. A little bit annoying, don't you think?
Yeah.
That you learn lessons halfway through a process. You're the one talking about history. Obviously, history didn't teach them anything. They came back and started with their bad habits.
But guess what? They learned from what had just happened.
Well, they should have learned from the fact that we're in COVID times, and they should have known better in the first place.
But at least it's better to correct.
Getting me excited now.
It's better to correct something that you think was wrong. Immediately you find out that maybe you could have done it better than to wait and say, since we've started, let's continue doing it. It can also seem unfair that you subject somebody
to 5 hours and then somebody to 2 hours.
To 2 hours or 30 minutes
point.
or something of that sort. But at least there seems to be some progress generally that we can agree on, that they are going to limit it. Obviously, you mentioned COVID. It's not even healthy
to confine
lessons. Yourself in a place for that long.
Not impressed with them generally. Anyway, so thanks, gentlemen.
I didn't say anything.
Yeah, but you did. You answered this one before I went to him.
My last comment.
Look,
in our quest to fight for progress, you don't take lessons from bogus past.
You take lessons from the past in general, including the bad.
Okay, so no bogus past lessons, but good lessons, take them.
Including the bad. Take lessons from the bad. You actually need lessons from the bad to make it good.
On that note, Nana, wrap us up, please. You had 3 issues to deal with. Your thoughts, and let's go.
My thoughts. All I can say is I'm astonished to see such impassioned or hear such impassioned debate from our 2 regular panelists. About this matter, that the business of changing the rules midway. Well, the point was well made earlier on by Dr. Ajiman about why you cannot just arbitrarily make up your mind that you're setting law aside. The decision to set aside law or set aside a common rule of thumb has to be based on precedent. If we keep on approaching things from a knee-jerk point of view, whether that's rulemaking for vetting committees or whether it's rulemaking for our courts, I think we'll find ourselves very rapidly coming unstuck. But I must say, from the public perception point of view, I think people have reached their tolerance level with a lot of these public processes. And people in charge of these institutions are going to have to think very carefully about how they present them in future.
You have to modernize?
Yes.
Based on lessons learned?
Yes. I mean, unless you can guarantee that you have structures that deliver moments of high drama, I don't think you're going to get people to want to allow the public money to be spent continuously on long-winded processes that only seem to be for the purposes of indulging the people who run them.
Okay, sitting allowances and things like that. Okay, on that note, we can say thanks to our panelists, our regular panelists, and we have to say happy birthday very quickly to Sydney Arnold Tay, Office of Corporate Affairs, Public Affairs Department. Doesn't tell me where, but it's Sydney, wherever you are, happy birthday. What else did you want to say?
I just wanted to say congratulations to our chocolate competition winner, Evelyn Asante of Lashibi and Tema. Thank you for entering, to all our listeners who entered the competition, but there could only be one. Next time we'll try and get more goodies to more of you.
Okay, Evelyn, look out for me. I'm the guy in black. I'll be delivering your chocolate later on today. That's the Asaase Breakfast Show. We come to an end. We'll be back same time starting from Monday. Have a great weekend and say bye-bye.
It's bye-bye from me.
And gentlemen, thank you so much for your impassioned pleas from your various corners. Professor Ransford Van Jampo, University of Ghana, and Dr. Kweku Ajiman Gimpa.